Good evening. So, as we were discussing importance of civil procedure is important even for our practice. So, you have to focus more on this topic. And same time, this is the only subject where easily almost everyone will score 10 out of 10 because at least 8 to 9 questions are from direct questions from Bare Act only. You can see index and answer few questions. You can open the book and answer few questions. Only 1 or 2 questions will be some concept based questions which you can answer by the I will be giving some notes, content, some important points while we are making the presentation itself. And after the presentation, I am sharing those things. Those points are enough. You will understand the concepts because I'm trying to give maximum important concepts explanation in the presentation itself. Okay. So last week we discussed about till section, I think 25. Okay. So here we will be starting with institution of suits. So stages in case. Okay. What are the stages in civil cases? We'll be covering maximum. We will be doing in this maximum sections and orders. I will be simultaneously covering this. So what are the stages of a case? The stages, it starts with institution of a suit. Once the institution of the suit, then they will issue and the service of summons, then appearance of the defendant, written statement and set of claims by defendant, replication, rejoinder by plaintiff, framing of issues. Then next stage is trial phase where the trial starts. Plaintiff evidence, cross-examination, defendant evidence, cross-examination of defendant and final arguments. Then the final is judgment phase where judge will issue the judgment. Then you can review the decree, you can go for appeal, and there is a execution petition for the decree to execute that award. Okay. So what is a suit? A suit is a civil proceeding initiated by the presentation of a plaint. So don't get confused. What is plaint? All those things we'll discuss some terms. Okay. A civil proceeding by presentation of plaint in the court of law, where the plaintiff seeks relief or remedy against a defendant for the enforcement or protection of a legal right. Okay. In simple terms, a suit is a formal process by which a person comes to court seeking justice. Are you able to understand? It is a formal process by which a person who comes to the court seeking justice, that some injustice happened to me. So I am presenting a suit. So that is a formal process where he presents his plaint to initiate the proceedings. A suit typically begins when a plaint is filed. Okay, it is under section 26. Plaint is filed. Okay, it is different from legal proceedings like applications, petitions, appeals. Plaint is different from applications. It is different from petitions. It is different from appeals. Plaint is different. Okay. So in every suit, so we've discussed about suit, right? So in every suit, there are two parties, two opposing parties. One is plaintiff, one is defendant. So we discussed about plaintiff and defendant earlier. So plaintiff is the one who files the plaint, right? So he is the one who institutes a suit against another claiming some relief. I want some relief. So he is filing a suit. Who is the defendant? Defendant is the one who against whom the suit is filed. Okay, against him, we are claiming relief from the defendant. Okay. Then there can be multiple plaintiffs, there can be multiple defendants, more than one plaintiff, more than one defendant. If there are two or more persons jointly filing a suit, they are called joinders of plaintiffs. Same thing, if two or more are sued jointly, it is joinder of defendants. Okay. Then we will discuss about necessary and proper parties and joinder and misjoinder of parties. Okay. So 1 minute. I think there is not covered in that thing. I'll speak about joinder because you may get questions on this joinder and this thing. Okay. So I'll talk about the joinder and joinder of parties and misjoinder of parties. Okay. I'll see if there is, it is there. It is not there. Okay. So as I told, when two or more parties, it is joinder. Same thing, if two or more are jointly sued, it is joinder of defendants. Okay, that is, you are clear, right? Joinder of plaintiff and joinder of defendant is there. So then the important thing is, who is necessary party? Okay, and proper party. Necessary and proper party. See, necessary and proper party are the people without whom the case is not properly cannot be adjudicated. Okay, they are important options. No order can be passed. Correct order can be passed. Say, let us say I am filing for a simple. I will tell you simple case. I am filing for a legal hair certificate, legal or succession certificate in the court. I am filing a simple suit, succession OP, SOP, that I am the legal heir of so and so person. Okay. If you are showing only you as a legal heir, you may be having a sister, you may be having a brother, but you are not disclosing them. But they are necessary parties. Without them, even if the court gives judgment, if the court gives the award, it will be challenged in future. If necessary party is not in the parties in the suit, it can be challenged at any future date. Okay. So here what will happen, if two brothers are there, two brothers will be plaintiffs and they will file a SOP. Here two brothers are called jointers of plaintiff. Okay. And they are claiming there are deposits in, let us say, 4 banks. State Bank, Union Bank, Central Bank, Bank of Baroda. There are 4 banks, they are having deposits. So these 4 banks, they have made parties. So they are jointer here. Okay, instead of 4 banks, you forgot about 1 bank. You made only 3 banks as parties and you have taken an award. Okay, you have taken an award against all banks except Bank of Baroda. So Bank of Baroda, when you go and say that, see, award is given against these 3 banks and my deposit is there, since already they have, I am proven that I am the successor. No, bank will not give you money until unless the award also should be passed against that bank. So necessary party here is that bank also. అర్థమైందా? సో మీరు సక్సెషన్ పిటిషన్ వేశారు, మీరు ఒక్కరే ఉన్నారు, కానీ మీ ఫాదర్ కి 4 బ్యాంకుల్లో డిపాజిట్స్ ఉన్నాయి. ఆ 4 బ్యాంకులను పార్టీలు చేయకుండా ఒక బ్యాంక్ నే పార్టీ చేశారు. ఆ ఒక్క బ్యాంక్ లో అయినా మీరే లీగల్ హెయిర్ అని చెప్తారు, 4 బ్యాంకులు అయినా మీరే లీగల్ హెయిర్ అని చెప్తారు. బట్ మీరు ఆ పార్టీలు చేయకుండా ఆ బ్యాంక్ కి మీరు జడ్జిమెంట్ కాపీ తీసుకొని వెళ్తే ఆ బ్యాంక్ దానికి వ్యాలిడిటీ ఉండదు. ఆ బ్యాంక్ నెసెసరీ పార్టీ అంటే పార్టీ అందులో డిఫెండెంట్ గా ఉంటేనే దానికి అగేన్స్ట్ జడ్జిమెంట్ ని వాళ్ళు ఇంప్లిమెంట్ చేయగలుగుతారు. ఆ బ్యాంక్ మీకు డిపాజిట్ ఇవ్వగలుగుతుంది. బ్యాంక్ అంటుంది నాకు ఆర్డర్ రాలేదు, నేను నీకు డబ్బులు ఇవ్వను అంటుంది. కాదు, నేను లీగల్ హెయిర్ అని వేరే బ్యాంక్ ఇచ్చారు కదా అంటే, నేను అందులో లీగల్ హెయిర్ అయితే ఇక్కడ కూడా లీగల్ హెయిర్ అంటే ఒప్పుకోరు. సో యూ షుడ్ మేక్ దెమ్ ఏ ప్రాపర్ అండ్ నెసెసరీ పార్టీ అన్నమాట, వితౌట్ హూమ్ ద judgment cannot be passed properly. So they can be challenging. If we are having any doubt, I'll clarify. It is clear? Okay. Non-joinder or of misjoinder of parties ante where the person is not required in that suit and he is made a party to the suit. Okay, it is reversed to necessary party of joinder. So he is not supposed to be part of the suit, but he is made a party to the suit. Okay. But అక్కడ ఒకటి చిన్నది ఏంటంటే అతను ఉంటే యూజ్ అవుతుంది అనమాట పార్టీ ఇందులో ప్లేంట్ లో. దేర్ ఇస్ నో క్లెయిమ్ అగేన్స్ట్ హిమ్. ఓకే, there is no claim, but you have made it because you want to make him a party. What are the types of civil suits? Okay, recovery of money. Before the class we discussed about something, jurisdiction, we spoke about this thing. Okay, possession, ownership, partition of a property, injunctions like stay suits or any stopping some specific thing, declaration like succession petition, what I was talking, it is declaring that you are a successor. Suits for partition, suits for damages, compensation, suits under specific relief act. Okay, see, civil suits, what are the uh, laws which will go under the CPC? Contract Act, Insurance Act, Property Act, okay, Specific Relief Act. So partnership acts, company law, all those things are substantive laws. So procedural law is civil procedure code. So you use those laws to implement those substantial these things. You will use CPC. Here I am talking about plaint. A plaint is a formal written statement by a plaintiff in a civil court setting out the facts of the case, the legal basis, and the relief sought. So it is a formal statement you are presenting in the court. What are the facts of the case? Why you are filing the case? What are the facts in that case? Then what is the legal basis for those facts, and what is the relief you are claiming? Okay. It is a statement of claim. It is the starting point of any civil suit. Okay. So here it is very important. Order 7, as I told initially when I was talking about orders, I told you go through all those things, but I told order 7 is very important because you can expect one question from order 7. Order 7 is the one where every plaint is filed based on order 7 rule 1. Okay, every plaint. So what are there in order 7 rule 1? How you will file a suit? Plaint. Okay, components of a plaint. So what are should be there in a plaint is given in order 7 rule 1. So every plaint should be in this manner. Name of the court. Okay. So where the court of plaint is filed must have a proper jurisdiction. I was name and description of addresses of the plaintiff and defendant. Clear identification is crucial. Okay, here name, description, address is required in a plaint. Name, so and so, son of or wife of, whatever it is, age, occupation. Okay, in some courts they even ask sex, male or female also they ask. Some courts they are not doing that. Okay, then address, correct address as per last records, whatever you are having. So that identification of the person is very important against whom you are filing, and the person who is filing is also very important. Who is filing, because name, father name, age, sex, all those things will give clear identification of the party. So name and description is very important. Then facts constituting cause of action. Okay, what are the facts constituting the cause of action? It can be 10 facts, 20 facts, what all those things you have to give. Then jurisdiction clause you will be there, whether this particular plaint is in the jurisdiction, pecuniary, territory, and subject matter jurisdiction, and what is the relief you are claiming. Valuation. So based on the valuation, you have to pay court fee. You have to give the valuation. This property, if you are claiming a property, this suit property is valued for 1 lakh rupees, and according to the if we are paying so much of valuation court fee, you have to mention. Then every suit there should be a verification. It is a signed statement confirming that the facts are true. To the plaintiff will sign the verification. Okay. Then the advocate also will sign. Then there will be the prayer clause is there. Okay. Section 26 of CPC talks about institution of suits. Okay, every suit, whenever you are filing any suit, it should be supported by an affidavit. So if you are filing a suit, you should give an affidavit along with the suit. Okay. So rules relating to the plaintiff is in order 7. Institution of suits is discussed in order 4. Okay. Institution of suits are discussed in order 4. Okay. You can see that order 4, institution of suits are there. Okay. Order 7 is rules relating how the plaintiff is to be filed. Then once the suit is filed, in the court, section 27, court will issue summons to the defendant to appear and answer. Okay, there can be one defendant, there can be 5 defendants, there can be 100 defendants also. So you will prepare the summons copy. So the plaintiff along with the plaint, he will give a document called process. In the process, you will file summons copies also. So on each party name, there will be a summon copy. So you will give a summon copy. Court will take it and stamp it and send it to the defendant. Court will send it directly. Plaintiff will not send a summon copy, but plaintiff can take permission of the court and send it. That is separate. But normally, court will send those, serve those summons. Okay. Order 5, the mode of service of summons will be there. And section 28 and 29 talks about service outside India and under other laws also. Other laws, when how it is served, the summons are to be served. And out of India, foreign country, how the summons to be served. These things are there. So section 27 talks about service of summons. So then here I have included orders in between of sections also, because of the flow of the suit, because we told institution of the suit and how the suit is filed, all those things. So it is going in that step. So I have included orders and sections simultaneously. So once the summons is served, appearance of the defendant is required. Okay. So if it is appear and non-appearance, I gave 2. So section order 9, it is important. Again, see, the order 9 is also important. Appearance of parties. Both parties must appear on the date fixed. Okay. Both parties must appear, or their counsels must appear on the date fixed. Non-appearance of the counsel or the party will lead to the dismissal for default or ex parte. Here, remember one thing: dismissal for default or ex parte decree. These 2 things are concepts. Okay, these are 2 things are concept. Dismissal for default. So dismissal for default, it will be if the plaintiff is not attending the case, it will be dismissed for default, because the plaintiff is not attending. It is called dismissal for default. And if the defendant is not attending the case, it is called ex parte decree. Okay. So you have to file, if it is dismissed, or you have to file for restoration of that suit. You can file that one, but it will be dismissed for default or ex parte decree will be given. Okay, once you have appeared in the case, after receiving the summons, the defendant has to submit a written statement. Okay, written statement, it deals with every material fact alleged by the plaintiff in the plaint. So whatever is the fact mentioned in the plaint, you have to answer for that fact. Say, let us say the plaintiff, there are 10 facts. You have to answer for each and every fact, whether you agree or disagree of each fact, you have to mention in the written statement. I am agreeing for this one. I am not agreeing for this one. I am agreeing. I am not agreeing. Whatever you want to mention, you can mention point wise. You have to mention in the written statement. Okay. If you don't mention, court will assume that you have agreed for that action. I mean, the point. Okay. Fact which the plaintiff is putting in the plaint. Okay. Then, so the written statement, this is a question came in last 19, AIBE 19, this question has come. So the written statement must be filed within, this is wrong, answer is wrong, they have removed this one. Okay. But so order 8 CPC says that the written statement must be filed within 30 days. You have to file the written statement within 30 days after appearing in the court for the first time. Okay, you appear in the court. Normally, they say from the date of summons served, but you can take it from the appearance date. Summons served, let us say you receive the summons today. From the date, within 30 days, you have to this thing. But it can be extended up to 90 days. Okay. And in the written statement, you can ask for set off and counterclaim also. Set off means this somebody asked in the group again. Set off is, say, let us say I filed a money suit that you had to pay me 1 lakh rupees. Then the defendant say, okay, I agree that I have to pay 1 lakh rupees. Same time, you have to pay me 50,000 rupees. So that's it. 50,000 is a set off. And defendant technically is saying that after setting off, I will be responsible only to pay 50,000. Okay. So the count, he can even counterclaim. No, I need not pay anything. You are supposed to pay me 1.5 lakh rupees. He can put a counterclaim also. So in written statement, he can set off or he can counterclaim also, or he can agree also. Whatever it is there, he can do anything. So once this written statement is given, okay, once the written statement is submitted, then examination of the parties will come. So court will ask them what are the matters in controversy. Oral examination by the court will be done. Matters in controversy means, see, you have given the facts, right? Facts in issues. Then I have said agreed, not agreed. So what are the matters or the issues not agreed? Those are the controversy matters. Issues I have raised in issue some in plaint. And in my written statement, I told I don't agree for point 1, I don't agree for point 2, I don't agree for point 3. So these 3 things are matters in controversy. Okay. Then court will frame issues as per order 14. So what is framing of issues? Court will frame issues which are disagreed by both parties. So I have raised 5 points in my plaint and I agreed on 1 point and I disagreed on 4 points. So the 4 points are issues, framing of issue. Frame issues will be framed on the 4 points. Those are disagreed by both parties. Okay. So it can be issues of fact and issues of law also. Then if court requires section 31 and 32, they will summon the witness also here. Then evidence will start, production of the documents. Then examination, cross-examination, order 18 of CPC will, the defendant's chief will be happening. First, plaintiff will give his chief, then there will be a cross-examination. Okay. Then, okay, same time defendant also will do. Okay, defendant, yeah, plaintiff evidence, defendant evidence, rebuttal. Okay, I think I did it twice. Okay, defendant evidence is also there. Then there will be cross-examination of both. After cross-examination, there will be arguments. Okay, oral argument can be there, and you can also give written submissions. A lot of people give written also. Then it is basically summarizing the facts in issues and what are the examination based on the evidence what we have given, which is strong, which is not strong, what counter arguments, all those things. Based on those things, you argue in the court. Okay. Then court will pass judgment based on the facts, evidences, and the arguments we have done. Court will pass, section 33 says, court will pronounce judgment and decree is passed. Okay, judgment and decree. So what is judgment also? It is there in the definition. It is the statement of decree, is the formal expression of the adjudication. So judge may pronounce or just he may give implementation part in the judgment. So we have discussed in the definitions clauses. Okay. So once this is there, a judgment is given, you can go for execution and the loser will go for appeal. So if the plaintiff, I lost the case, I'll go for appeal. If the defendant lost the case, he will go for the appeal. Okay. The person, if the plaintiff wins the case, he files an execution of the decree. So execution of the decree, all things are not important. 36 to 74 are not important. Few are important. Okay. So 36 to 74 talks about execution provisions. And same time, order 21 talks about execution of decreases, modes, arrest, attachment of the property. So order 21, I told specifically because you have to remember orders also, because attachment of property they may ask, sale of property they may ask under which order. So it will come under execution of property. Okay, execution will be in the under order 21. So at least you should recollect that one. Otherwise, you keep wasting some time. It is not that those so difficult, but you can look into that one. So execution will be order 21. You can go through the headings also. In the index, you will find it out. So, but you should know sale of property is from execution. Attachment is from execution. At least those things you should understand. Arrest in civil suit is from execution. Okay. So those basic things, if you don't know, then you will not, you don't know where to search. Then same time, appeals, review, revision. Okay. So this is appeals and reviews and revision is in section 96 to 115. Somebody asked about 115, right? Just now. Each stage ensures, okay. So 115 is important question. So this is the flow. Okay. Then once this is the stages of case. So stages of case very important because every civil suit goes through all the stages, and these are the stages every advocate will be involved in and out. Okay, so you should remember these stages very important. And you should remember those procedure flow. That is the reason I have taken the flow, because it will be easy for you to go through the sections also. The sections and orders also will follow in the similar sequence, almost in the similar sequence. Just I'm going through the Bear Act, just checking if there is anything important. So part 10 is not so important, and somebody asked which are important. Part 10, part 11, few are important. Okay. Section 152 is important. Amendments of judgment and decrees is important. 132 is important. 134 is important section. Okay. 137 is important. 138 is also important. So some are important. Otherwise, part 11 is not so important. Part 9 is not important. Part 9 you can, just index questions you may get. Part 10, see, as I told, there will be 1 or 2 questions which will be from concept. Maximum questions will be from Bear Act only. So you should know where that particular section or order lies. Okay, once you understand the flow, that is the reason I gave focus on the stages of cases. Once you understand the flow, just imagine how the flow happens. So it will come mostly in that sequence only in the Bear Act. Okay. Then in the other than this one, there are separate examination admissions are there. Main other thing is order 35 is important. We'll talk about those things in next suits relating to interpleader, special cases, summary suits. This is important. These 2-3 things we will talk in next session, because I want to talk about this thing in separate class where interpleader we can talk. Okay. I think we discussed about interpleader. Somebody asked in the group, what is interpleader? Okay. Then I'll talk about summary suit here itself. I'll try to finish summary suit. We are having some time, another 10 minutes. I'll try to finish summary suit. Summary suit is very important suit for recovery of money. Okay. It is for recovery of money. It is filed under order 37. Okay. The only thing, see, principles of natural justice is followed in Indian law. Okay, so principles of natural justice, what it does say, you have to give a notice and you have to hear the defendant, let us say in this civil case. So, but in summary suit, this summary suit is the only suit where defendant is not having right to defend. Try to understand very carefully. You may get this question. No right to defend. So then what is the thing? How can it be a case? Okay. So summary suit is filed. Once a summary suit is filed under Order 37, the defendant should appear in the court himself or through his counsel within 10 days of receipt of the summons. Within 10 days, he has to attend the court. If he is not attending the court within 10 days, the plaintiff is eligible for ex parte award. Okay? Within 10 days. Summary suit will happen within 20 days. Technically, I mean, after, forget about the notice period, all those things. After service, notice can take 10 days time. From the receipt of 10 days, the defendant should come or his counsel should come and file a memo in the court and some bakalat, whatever it is, that he is representing on the day. If he is representing within 10 days, if he is appearing in the court, the plaintiff will give summons for judgment. Okay, summons for judgment. Once the defendant receives that summons for judgment, he has to file that he will defend that case. He wants to defend that case. He has to take a permission of the court to defend that case. You got it? He has to write a affidavit. Sir, I am having some merits in this case. This case is not what actually it is mentioned in the plaint. I am having certain merits. So please allow me to defend this case. So the court is having discretion based on the plaint and objections of the plaintiff. If the court feels that there is a proper chance for the defendant, they will allow the defendant to submit written statement. Or else court will not allow the defendant, they will pass on the judgment in the next 10 days. Okay, that is summary suit, power of the summary suit. Summary suit cannot be happen in every case. Only few cases are there. I'll talk about those things also. Okay, so
sir, sorry, sir. Sir, in that case, then why are they calling defendant, sir? They can directly. I mean, actually, what is? What is the main advantage of this summary suit, sir? I mean, why the court is it's not allowing the defendant to defend himself in this case?
Yeah, I'll tell you about that. See, you have to go into jurisprudence. You have to go in depth. I mean, I'm just giving the basic thing for the AIBE, but anyhow, since you have asked, I'll tell you. See, this summary suit can be filed only against money-related cases. Okay, money recovery cases where there is proper evidence, like check is bounced. You are filing 138 case under NI Act.
Yes.
Simultaneously, you can file under summary suit also, civil suit also. You can file check bounce cases. Then there is a promissory note. You have taken, there is proper evidence, and I can file a summary suit. Okay, I have paid through bank and you have taken that money. There is a receipt. There is a promissory note. There is some contract. There is a bill of exchange. There is some negotiable instrument, whatever it is. Then business transactions are there. I sold some products and you are not paying that money. Okay.
Okay.
For that liquidated damage, and for contracts, there should be liquidated damage. So money should be specific. It should not be ambiguous. There should be very clear. I gave a check for 1 lakh rupees, it bounced. So I'm claiming for 1 lakh rupees with interest. You can say with interest separately. So it should be very clearly mentioning that I am claiming 1 lakh rupees. Check is given. I lent the money. I transferred that money to him. He issued a check and a promissory note. I am enclosing the promise note and the check is there. So he is supposed to give the money. This is a simple thing. Then when the person, he is filing an affidavit to defend, see, court will give a chance. Okay, they will say that first he will file an affidavit. No, I haven't taken the money. That is a fraud check. That is not my signature. All those things. Okay, if there is a reasonable evidence, then court will allow him to defend. Okay, he can file, then it will become a regular suit. Once court allows, him to defend, then it becomes a regular suit. If court is not allowing, then it will become a summary suit. Court, while allowing, they may say, okay, you do one thing, it is 1 lakh rupees, you deposit 1 lakh rupees in the court, then we'll start the proceedings. Or you can deposit 50,000 rupees in the court, then we'll start the proceedings. Court can impose some cost on that one, or they ask for some amount to be deposited, then they will say they will allow to proceed. Okay, it depends how strong is your case, what is the evidence you are submitting. See, evidence we don't submit, but how the facts in issue are there, then the court will say, see, once the ex parte court will say that we are passing the decree ex parte, since the defendant is not appearing within 10 days, or even he appeared and he is not filing for defending, he didn't file affidavit for defending within another 10 days. And even if he filed a affidavit for defending and court is not allowing, then court will pass on the judgment in another 10 days. Okay. Then after that, it will say ex parte, then you have to file your, give your evidence, then judgment will be given. This is the process in summary suit. Okay. So summary suit, lot of people don't do, lot of courts will not do because the procedure is little bit confusing. Okay. So people will go straight to regular courts. Okay. Regular things. So that is very important. Summary suit, you get a couple of questions. Next chapter is 38, arrest and attachment of before judgment. See, that is injunction signed, those things. So if you feel that the property is sold, they will attach that property before the judgment also. If you feel that there is a fight for a property and you fear that the property, the person is ready trying to sell the defendant, they can attach that property. Or if he's ready, say, let us say in money suit, he is not having anything except some property and that person is about to sell the property and run away, they can arrest him, that they can attach the property so that he cannot sell. So, and there is a possibility if he sells that, you will not recover that money. Okay. Temporary injunctions and interlocutory orders are also given. Temporary injunctions are to specific relief and interlocutory orders are also given. These things are, this is also important. 39 is important. Appointment of receivers, no, you will not get these things. Okay. See, decree holder is one important concept basic question. Decree holder is the person who got the award in his favor. That is, plaintiff, if is getting award in his favor, it is called decree holder. Okay. So this concept based questions also you'll get. So